Yes, I do, because I was dealing with the situation at the time. Part 4 of the Anti-Terrorism, Crime and Security Act, which was struck down by the Law Lords in December 2004, which had passed through both Houses of Parliament and had been amended quite strongly in the House of Lords, tried to balance not taking away the rights of British citizens with the evidence that was being adduced about the risk of attack, and therefore the small number of people who were not UK citizens who posed a threat to our life and liberty. And the context of that was that at the time it was believed, and I think it was probably true at that moment, that most of the immediate threat was from externally organised forces as opposed to homegrown terrorism. And therefore the people that we were intending to certificate in the end 17 actually were people who had infiltrated into the country, who were being manipulated and directed from outside, and who posed a threat in a way that was difficult to deal with in open court. And it was the Lords, it was the Law Lords, part of the Lords, that actually suggested that we should use that particular part of existing immigration law, which allowed for the equivalent of a High Court process to be adopted, the tribunal, with lawyers representing the individuals concerned, so that they would have representation and that their case would be heard by a High Court judge. But the lawyers taking the case would be on an approved panel, i.e. they themselves would have been security vetted. Now it sounds really clumsy, but at the time the alternative was going to be control orders, which were eventually brought in 2005 by my successor Charles Clarke, which caused the most enormous controversy, then changed to TPIMs by Theresa May, which themselves have then been challenged and which have proved to be fairly ineffective. There's 4 or 5 people on the run at the moment who the police are still trying to pin down. So we've, over these last, 14 years, we've tried very hard to try and get this right within the context of overall British law. In the end, I think we've never come to terms with the fact that you sometimes will have to present evidence in closed session, but with all the existing rights that people would expect to have still in place, but not with the case being publicly reported and with the lawyers having been cleared security-wise, because otherwise you always get yourself into a twist that you can't present certain parts of the evidence because it would reveal the work of the intelligence and security agencies, or you don't take the case at all, and I still don't think we've come to terms with that. So a rather convoluted answer, but you are lawyers and you do understand that